Hello all, let us continue with our discussion on the previous year questions. This would be our lecture number 3. Before this, we have already seen 2 classes. We have completed the philosophical part, the question that was coming from the philosophical part. We have covered the topics or the questions from the fundamental rights, the directive principles of state policy, fundamental duties and the preamble. So this would cover the philosophical part, and we have also seen that around 3 to 4 questions has been coming every year from this particular area. So now we will move on to the next part of the discussion, that is the system of government. So what is covered under this particular topic? The important understanding of what is called as a parliamentary democracy, what is a cabinet form of government, what is federalism, what is separation of powers. So we are going to deal with all these things in today's class, and every year you can expect one question, definitely one question from this particular area. And then once we are done with this particular part, I think we'll also have time to start the executives today. The executives would cover the most of the important topics like the president and the governor. Every year there's a question either from the president or the governor. And then we'll also touch upon the other executives like the prime minister, the council of ministers, the chief minister and the council of ministers, the advocate general, the attorney general. So all these topics you can expect again 2 to 3 questions in the examination. So we'll start with the system of government, and then we'll move on to the executives. Let's get into the question. The first question for today is from the system of government. So the first question is a parliamentary system of government. So please understand, a parliamentary system of government is one. So the question is trying to elicit the response of the student or try to test the response of the student as to what is a parliamentary system of government. The parliamentary system of government is very important topic for your examination. So basically, what is a parliamentary system of government? To understand as to what is a parliamentary system of government, students should have certain basic understanding. In fact, if you go to the debates in the Constituent Assembly, when they were drafting the constitution, there was a debate that either India should go for a parliamentary democracy or a presidential democracy. There are 2 options in the hands of the Constituent Assembly. But however, the majority of the members in the Constituent Assembly has chosen in favor of the parliamentary democracy. The reason being, one is India has already been some sort of parliamentary democracy was there even when the Britishers were ruling India. I wouldn't say that it is a complete democracy because there was no complete adult franchise, but they are familiar to this particular system. That is one of the reasons they have chosen parliamentary democracy. But most importantly, they have chosen parliamentary democracy because they wanted the government to be accountable. So accountability is one single reason as to why they have chosen the parliamentary democracy. So what do you mean by accountability? Accountability means answerability to their action. And who is to accountable? The executives have to be accountable to the legislature. The executive accountability to whom? To the legislature. That means the legislature can make the executives accountable in a parliamentary democracy. And for which they thought which type of government would be the best? They thought that the parliamentary form of government would be the best. So what exactly is a parliamentary form of government? We say that India is a democracy. Very good. Democracy means it is the people who will decide as to how the government is formed, or the people will form the or decide. The people will vote, and through their right to vote, they form the government. But however, in a parliamentary democracy, please understand how the government is formed. People elect their representatives. So people elect their representatives, and these representatives are nothing but the members of the parliament. People elect their representatives. The representatives, from the representatives, the government is formed. We know that in our country, after the election is over, and any party or a coalition of party which has got the majority will form the government, and usually the leader of the majority party is appointed as the prime minister. And then the prime minister will recommend the names to the president, and then the president will appoint the other ministers as well. And in fact, the leader of the majority party is also appointed as a prime minister by the president. So the government is formed. So this is what is called as the parliamentary democracy. So from where the government is formed, the government is exactly formed from the Lok Sabha in our country, which is a part of the parliament. And this is not the complete explanation as to what is a parliamentary democracy. So this partially explains as to why it is a parliamentary democracy. But most importantly, once a government is formed, this government is continuously accountable to the legislature. To be very specific, this government is continuously accountable to the Lok Sabha. Now, how it is continuously accountable to the Lok Sabha? Because at any point of time, not only at the time of forming the government, at any point of time, the government should always have a majority in the Lok Sabha. If they do not have the majority in the Lok Sabha, then this government can be dismissed by the president at his pleasure. That means the legitimacy of this particular government, which is formed from the Lok Sabha, will be there only when they have the majority in the Lok Sabha. And at any point of time, the opposition can introduce a no confidence motion and they can test the majority. And if there is no majority, then this government can be tested. So, on a continuous basis, there is accountability on the part of the executive to the legislature. That is the one single most defining factor as to why India has gone for, or rather the Constituent Assembly has chosen in favor of the parliamentary democracy. So, with this understanding, come to this particular statement. A parliamentary system of government is one in which all political parties in the parliament are represented in the government. In fact, that's not the case. In India, not all the political parties are represented in the government. In fact, it is only the majority party or maybe their coalition partners. You cannot expect the members of the parliament from Congress to be part of the government. That is not possible when BJP is having the majority. So, this is not true, at least in the Indian case. The government is responsible to the parliament and can be removed by it. The government is responsible to the parliament and can be removed by it. I'll just come to option B again. The government is elected by the people and the people can be removed by them. The people can elect the representatives and from the representatives the government is formed, but the people have no right to remove the government. All that the people can do is when there is a periodic election, again they can vote in the elections, but they cannot remove the government. So, that's not possible. India does not have an option of direct democracy or the right to recall. That is not possible in our country. So, this is wrong. The government is chosen by the parliament but cannot be removed before the completion of the fixed term. There is no concept of fixed term for any government. That's the beauty of the parliamentary democracy. What is the beauty of parliamentary democracy? As long as you can command the majority in the legislature, that is in the Lok Sabha, you can rule this particular country. And when you do not have the majority, you can be removed by the parliament. To be very specific, by the Lok Sabha, by passing a no confidence motion, thereby making the executives accountable to the legislature. So, this is also not true. So, the right answer would be the government is responsible to the parliament and can be removed by it. To be very specific, it is responsible to the Lok Sabha, and in fact, Article 75 of the Constitution talks about the collective responsibility of the government, that is the ministers to the Lok Sabha. That means they should always have a majority in the Lok Sabha. This is what is very important. And that is exactly what is the parliamentary democracy. And that is the reason why the Constituent Assembly has chosen the parliamentary form of government over the presidential form of government. Next question. Democracy's superior virtue. What is something superior about the concept of democracy? Democracy's superior virtue lies in the fact that it calls into activity. What is democracy? Before we answer this question, democracy, you can understand it is a combination of two words, demos plus kratos. Demos meaning people, kratos means rule. So, put it in a very simple way, what is democracy? Democracy means rule by people. The people will rule that particular country. In certain times during the ancient time, that the people directly ruled the country, but as and when the function have become more complex, when the territory of the countries have expanded, so they thought that the direct democracy is not possible, so we'll bring in what is called as an indirect democracy. So, many democracies across the world today, presently, most of these countries are indirect democracy. India is also an example of indirect democracy. That means the people do not directly rule. So, the people elect their representatives on behalf of the people. These representatives rule this country. And somebody who is having the majority in these representatives, they form the government and then they rule. So, what is the superior virtue about this particular democracy? In any democracy, you will have to understand ultimately who elects the government? The people. The people are responsible for someone to form the government. And how the people exercise and how the people elect their particular government? Through the right to vote, which is also called as the concept of adult franchise. In most of the countries, they follow the adult franchise. In India, we follow universal adult franchise. That means anyone who has attained 18 years of age shall have the right to vote. Article 326 of the Constitution deals with adult franchise or the adult suffrage, that anyone who has attained 18 years of age shall have the right to vote. Article 325 of the Constitution is talking about that this adult suffrage is not only the adult suffrage, but it is universal in nature. That means there shall be no discrimination on the grounds of religion, race, caste, sex, or any of the other factors. So that means in any democracy, the most important thing is there is universal adult franchise, and using the right to vote, people elect the government. That means look into this right to vote. This right to vote is not specifically given to anybody who is having a specific educational qualification, or someone who is very rich, or someone who is paying much taxes to the government. But it is given to every ordinary men and women, this right to vote, and using this right to vote, they shall elect their particular government. So that means the very important virtue of parliamentary democracy is the intelligence and character of an ordinary men and women. So that is the most important virtue. Any man or women with 18 years of age, they shall have the right to vote. So that's what the Constitution says. So that is the most important concept of the democracy. That is the most important virtue of democracy. Come to option number B, the method for strengthening the executive leadership. So this is not relevant to what has been asked. The superior individuals with dynamism and vision, not necessarily. Then it is not democracy. Democracy means everybody shall have the equal right with regard to electing their government. A band of dedicated party workers, no, this is not the case. So option A is the right answer. Please understand as to what is democracy and what is the idea behind democracy. Come to the next question. The main advantage of parliamentary form of government is that, so we have already discussed that. So see how the questions are getting repeated in most of the years. In fact, the single concept of parliamentary democracy has been asked more than, I think, 3 to 4 times in the last 10 years. So you can understand the importance of this particular question just by understanding one single concept. So again, what is the main advantage of parliamentary form of government? The main advantage of parliamentary form of government is that it can make the executives accountable. And how the executives are accountable to the legislature? The executives are accountable to the legislature because the executives will have to continuously maintain the majority in the Lok Sabha. And when they lose the majority, then this government can be dismissed by the president. So the executive and the legislature work independently. In fact, this is not the case in India. In fact, there is some element of overlap between the executive and the legislature. And the concept of separation of powers, which talks about complete separation between 3 organs, it does not exist in our country. There is some element of overlap between the legislature and executive. But anyways, this is not related to what is parliamentary system. 2, it provides continuity of policy and is more efficient. When you talk of it provides continuity of policy and is more efficient, it is necessarily not the case, because in a parliamentary democracy, whoever the people elect, then a next government can come and the next government may have the same policy or they may come out with a different policy. So not necessarily this is the case. The executive remain responsible to the legislature. So this is the single most important factor. The head of the government cannot be changed without election. That's not the case. The head of the government can be changed even without the elections. Suppose if the prime minister die, a new prime minister can come from the same Lok Sabha. Even when the prime minister is there, the legislators may withdraw the support to that particular party for that particular leader, and they can elect a new leader, and whoever is able to have the majority in the house, he or she may be appointed as the prime minister. That is very much possible. So in India, you can see there are instances where within the same Lok Sabha, there have been multiple prime ministers. So that is very much possible. You need not go for a re-election as long as a person who is elected as a leader is able to possess the majority. So this is also wrong. So the right answer is option C. See how the questions are getting repeated, the same concept which has been asked again and again. Come to the next question. Out of the following statements, choose one that brings out the principle underlying the cabinet form of government. So what is this cabinet form of government? So for which you'll have to understand as to basically what is this cabinet. And to understand this particular cabinet, you will have to understand the way that the government functions in our country. In fact, if you see, the only place where this particular cabinet is mentioned in the Constitution is Article 352 of the Constitution. The 2 was not mentioned originally, but later it was added by the 44th Constitutional Amendment Act in the year 1978. In fact, what this Article 352 of the Constitution is about, Article 352, which may not be completely relevant to this particular question, but you still should know as to what is this Article 352 because of the word cabinet being mentioned in Article 352. Article 352 gives a power to the President to impose or to proclaim the national emergency. So, this is what is the power of the President. But in the original Constitution, it says that the President can impose a national emergency, proclaim national emergency only on the aid and advice of the Council of Ministers. If the Council of Ministers do not advise, then the President cannot do that. But however, there is no explicit mention as to how this advice is to be given. So, everybody thought that this power may be misused, and that has exactly happened during the third national emergency, because third national emergency was proclaimed by the President. It was advised, according to the historians, only by Prime Minister Indira Gandhi, and then subsequently in 1977, when there was an election, the Janata Party came to power. The Janata Party made an amendment to Article 352 of the Constitution, and they inserted a word what is called as cabinet under Article 352. The 44th Constitutional Amendment Act 1978 made sure that henceforth, if at all a national emergency is to be proclaimed, it can be proclaimed by the President only on the written communication of the cabinet. So, the cabinet has to give a written communication. So, in this context, you have to understand as to what is this particular word cabinet. Very, very important. So, if you look into the transaction of business rules in our country, which the President can decide under Article 77 of the Constitution, the ministers in our country, we always use the expression Council of Ministers. But the Council of Ministers, there can be different, they can be further classified into different categories. If you think this to be the Council of Ministers, the Council of Ministers can be further divided into three broader categories. The first is the Cabinet Ministers. Minister with a cabinet rank, that means these are the most important ministers in the government. There can be number of ministers, let us assume there can be 70 to 80 ministers in our country right now in the union government, but among them, who is the most important of these ministers? The ministers with cabinet rank. And who will be given the cabinet rank? Who will decide as to who shall be given the cabinet rank? The Prime Minister will decide that. The Prime Minister himself is a cabinet minister. In addition to that, he may choose his own team of cabinet ministers. So, for example, Mr. Amit Shah is a cabinet minister today. Mr. Rajnath Singh is a cabinet minister. Mrs. Nirmala Sitharaman, she is a cabinet minister, and there can be many other cabinet ministers. There can be 15 to 20 cabinet ministers. So, what is so special about these cabinet ministers? It is because they have the confidence of the Prime Minister. They are very senior leaders in the respective parties, and they have a lot of experience with regard to the public life, and also that they occupy the most important portfolios of the government. Take the example of Home Ministry, take the example of Finance Ministry, Defence Ministry, Agriculture Ministry, Road and Highways Ministry. So, they have an independent charge of all these ministries. So, all these people are called as cabinet ministers. And then there are next set of ministers who are called as the Minister of State, MOS, which means Minister of State. So, Minister of State is the next level of leadership after the cabinet minister. The next level of leadership, which is the Minister of State. And this Minister of State, please understand, they can be further classified into two types. Minister of State with independent charge and Minister of State with no independent charge. So, they may have an independent charge, or they may just help the cabinet ministers in discharging their duties. So, for example, Mrs. Nirmala Sitharaman, before she was elevated to the cabinet rank, so initially she was given the status of a Minister of State independent charge. That means although she was a Minister of State by the status, but she was having independent charge of the Finance Ministry. She was not working under a cabinet minister. But however, most of the Minister of State who are not having any independent charge, they work below a cabinet minister. They help the cabinet minister in discharging their duties and responsibilities. They cannot take any authoritative decision with regard to that particular ministry or department because they are not given independent charge. They are just working under a cabinet minister. But however, a Minister of State with independent charge, he or she may not be a cabinet minister, but they have an independent charge and they can take the decisions with regard to that particular ministry. And then the last level of ministers are called as the deputy ministers. So, these deputy ministers are anyways not given any independent charge. These are the lower level of ministers. That means they are in line for succession. They are going to learn either from the cabinet ministers or the Minister of State with independent charge. But for the future, they may be groomed and they are important to the party, but not presently because they may not have much experience. So this is how the Council of Ministers are grouped. But however, please understand, in India, although there is a portfolio system, that means every department or ministry is given to a cabinet minister or a minister of state with independent charge. But not necessarily most important decisions of the government are taken by an independent minister. Say for example, tomorrow there is some kind of incursion in the border and there is a war-like situation, let us assume, unfortunately, war-like situation in the border, and then the defense ministry alone cannot take a call whether India should go for a war with a neighboring country. So probably this decision will be taken by the cabinet. That means the prime minister is head of most of the cabinet committees, and the prime minister will call for all the cabinet committees, or the prime minister will call for the ministers to attend the cabinet committee meetings, and there are different cabinet committees for this particular purpose. So the example that I have taken, the prime minister will call upon the cabinet committee on security. The cabinet committee on security will also be headed by the prime minister. So in this particular issue, he may call upon the defense minister, he may call upon the home minister, he may call upon the finance minister, he may call upon the Ministry of External Affairs. In addition to that, he may call upon the other ministers also, whom he thinks is necessary to take a decision on this particular matter. Collectively, they will discuss and then they will take a decision. So this is what is called as the cabinet form of government. So what is a cabinet form of government? A cabinet form of government means not the important decisions of the government is taken by a single ministry or a department, but by a group of ministers who are all with a cabinet rank, which is headed by the prime minister through their cabinet meetings. So this is what is cabinet form of government. So what is the advantage of this cabinet form of government? The very advantage of this cabinet form of government is that the government will take a more responsible decision. See, an individual minister taking a decision can take it at a much faster rate, or he can take a fast decision. But what is the advantage of cabinet? So cabinet means you are bringing in all the ministers, it becomes more participatory, and it also ensures a collective responsibility of the government. So that's the very idea behind the cabinet form of government. Come to the statements with the following information. An arrangement for maximizing criticism against the government whose responsibilities are complex and hard to carry out the satisfaction of all. So this is not very relevant to the question. A mechanism for speeding up the activities of the government whose responsibilities are increasing day by day. In fact, the idea is not speeding up. In fact, an individual minister taking decision can even speed up the process rather than going for a cabinet meeting. So that's not the idea. A mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. So this is true. It is for the collective responsibility. A device for strengthening the hands of the head of the government whose hold over the people in a state in decline. So this is also not true. So the answer is option C. So try to understand the concepts like parliamentary democracy, the cabinet government. So all these things are very, very relevant. Come to the next question. Which one of the following is not a feature of federalism? So which one of the following is not a feature of federalism? So first we'll have to understand as to what is federalism. So federalism is very much inherent in the constitution. So what is federalism? So federalism means that the constitution is there and the constitution itself is giving certain powers to the center and it itself gives the power to the states. So this is what is called as federalism. So federalism means that there is a division of powers between the center and the state. The center cannot unnecessarily infringe in the domain of the states and the state cannot unnecessarily infringe in the domain of the center. And if these things happen, then there has to be an independent mechanism. There has to be a mechanism to arbitrate the dispute between the center and the states, which is of course, which is done by the Supreme Court of India under Article 131 of the Constitution. So we have already seen all those things, the federal disputes and all those things. If you want to see more explanation for these things, you can go on and watch the 100 most important topics for prelims 2023, which is the previous series of video that has been already uploaded in the StudyIQ English channel. So we have comprehensively explained the jurisdiction of the Supreme Court, including the original jurisdiction. So coming back to what I was discussing. So federalism means that there is division of powers between the center and the state. So in order to ensure that they independently derive their powers from the constitution. So no authority can be seen as a subordinate of another authority in a federal political system. But what if one authority is trying to encroach the authority of the other? In that particular case, they can approach the Supreme Court of India under Article 131. For which please understand that the Supreme Court should be an independent authority. If the Supreme Court is dominated by the central government or if the Supreme Court is under the pressure from the central government, do you think that the Supreme Court can give an unbiased decision with regard to the dispute between the center and the state? So, independence of judiciary is very much inherent and integral to ensure the federal political system. Without the independence of judiciary, you cannot have that. So, come to this particular question. Which one of the following is not a feature of the Indian federalism? There is an independent judiciary in India. Independent judiciary is a feature, but the question is asking for not a feature. So, this is not the right answer. Question number 2, statement number 2. The powers have been clearly divided between the central and the state. So, this is very much true for federalism. So, the question is not a feature. So, this is also not true. The power has been clearly divided. Say for example, police is an item in the state list. So, police will be controlled by the state, but the national security defense is an item in the union list. So, the army will be controlled by the union government. So, in this way, what is the power of the center? What is the power of the state? What is the area on which the parliament can make laws? What is the area on which the state legislature can make laws? All these things are clearly demarcated. That is very much essential and inherent to the federal political system. Statement number 3, the federating units have been given unequal representation in the Rajya Sabha. So, that is also very true in our federal system. In fact, Rajya Sabha is the very idea of having Rajya Sabha in the parliament is also to give effect to the federal political system, to institutionalize federalism in our country. This also we have been, this has also been explained in the previous lectures. But however, in India there is unequal representation, and this representation is basis of the population, which is given in the Schedule 4 of the Constitution. So, this is also a federal feature. So, this is also not the answer. The only thing that is left out is it is a result of an agreement among the federating units. In fact, please understand, in India, it is not a result of agreement among the federating units. India always existed as mostly a single country, a single nation, even under the Britishers, except for certain princely states which were having certain autonomy. So, it was never a result of the agreements among the states. So, that is why we say that India is a holding together federation and never a coming together federation. It was not that the different states that they came together and they entered into an agreement, as it has happened in the United States of America during the American Revolution, but India is a holding together federation. So, this is basically not the characteristics of Indian federalism. So, this is wrong, which is not a federalism. So, this is the right answer. So, in this case, the right answer would be option D. So, please have an important understanding of the various provisions which are related to federalism and which is a non-federal feature in the Constitution. Come to the next question. There is a parliamentary system of government in India. See, again the same question from the parliamentary system is asked. So, what is the answer? Very simple thing. There is a parliamentary system of government in India because that the Council of Ministers are responsible to the Lok Sabha. So, directly you can arrive at the answer. The single most factor for India to have a parliamentary system, in the opinion of the Constituent Assembly, is that it makes the ministers more accountable to the legislature on a daily basis. Anytime the vote of no confidence can be introduced. Okay, so that's the most important factor. Anyways, we'll have a look into the other options as well. The Lok Sabha is elected directly by the people. It does not necessarily make it to be a parliamentary democracy. For example, in USA, there is a presidential democracy. You all know that there's a presidential democracy. In USA also, their House of Representatives, which is similar to that of Lok Sabha in India, is directly elected. That does not necessarily make it as a parliamentary democracy. So, this is wrong. The parliament can amend the constitution. The Parliament of United States of America, which is their Congress, that can also amend the constitution. That does not necessarily make it a parliamentary democracy. So, that is also wrong. Rajya Sabha cannot be dissolved. The Rajya Sabha is a permanent house. So is in case of United States of America also. The Senate is a permanent house. That does not necessarily make it as a parliamentary democracy. So, this is also wrong. So, either you can cross verify like this, or you can directly go when you know the answer. Depending upon the time, you can follow the approach. But in this case anyways, you know as to what is a parliamentary democracy. Let's move to the next question. In the context of India, please understand, in the context of India, which of the following principles are implied institutionally in the parliamentary government? See how many questions are coming just from the concept of parliamentary democracy. A very simple concept. If you understand, you can solve most of the questions that comes from this particular area. See what is the statement? The members of the cabinet are members of the parliament. That's very much true. The members of the cabinet are members of the parliament. The members of the cabinet here means the members of the government or the members of the council of ministers. So whenever we use the word cabinet, that means they are part of the council of ministers, but within council of ministers, they are the most important people. When you say the members of the cabinet, that means the members of the government, the ministers, or the members of the parliament. So only from the parliament they can become the ministers. Although there is an exception that anybody can be appointed as a minister even if he is not a member of parliament, but he has to become a member of parliament within a period of 6 months. That's an exceptional case, but generally this particular statement is true. Because look into the statement of UPSC, the idea is not to see whether the individual understands the exception or not, whether he knows about the expression or not. The question is framed in such a way, the question has been framed to see whether the candidate knows the general information, general idea as to how the ministers are coming in India. So this particular statement is true. Statement 2, the minister hold office till they enjoy the confidence of the parliament. So this is also very much true. So this is exactly how it ensures the accountability of the government to the legislature. The ministers hold office till they enjoy the confidence of the parliament, or to put it in another way, the legitimacy of the government comes only when they have the majority in the Lok Sabha. As long as they have the majority in the Lok Sabha, they can continue the government. At any point of time, then the legislature withdraws the support, then the government will be dissolved. They have to resign, or otherwise the president can dismiss this particular government. So this is also true. Statement 3, the cabinet is headed by the head of the state. Who is the head of the state under the Constitution of India? The head of the state is the president. He is the de jure head. De jure means under the Constitution, who is the head of the state? He is the head of the state. But although the president is given only a position of a nominal executive, he is not the real power center, although all the actions of the government are taken in the name of the president. But the president cannot do most of the things on his own. There are few situational discretion and few constitutional discretion, and at certain times he can exercise. But otherwise, he has to act in accordance with the aid and advice of the Council of Ministers by virtue of Article 74. And who heads this Council of Ministers? It is headed by the Prime Minister. So who is the head of the government in our country? So he is the head of the government in our country. So with this information come, the cabinet is headed by the head of the state. In fact, cabinet is what? The cabinet consists of the most important ministers, and this cabinet is headed by the prime minister and not by the head of the state, that is the president. So this particular statement is wrong. So select the correct answers using the codes given below. So the right answer would be, if you eliminate 3, you are left out with only just option A, that is 1 and 2 only. So very simple understanding. Once you know the provisions, you try to apply these things when you read the news articles and all those things, you will have a proper understanding of as to most of the things that you read in the polity. Come to the next question. Question number 53. The Indian parliamentary system is different from the British parliamentary system in which context? Now please understand, the parliamentary system in India is mostly modeled on the lines of the British parliamentary system. But that doesn't necessarily mean that we are completely following whatever is followed in the British parliamentary system. There are few differences when it comes to the Indian parliamentary system, although by essence and by the majority of the things which is similar to that of the British parliamentary system. But there are few differences, and what those differences are, let us try to understand. So both real and nominal executive, that means in India and in United Kingdom, there is a system of both real as well as the nominal executive. This is very much true. The real executive is the Prime Minister in both the countries, and the nominal executive in case of India is the President, and there it is their monarch. So this is true in both the cases. So the question is, which the Indian parliamentary system is different. So this is not different, this is same. So this is not the right answer. A system of collective responsibility. A system of collective responsibility means under Article 75 of the Constitution, it says that the Council of Ministers shall be collectively responsible to what? They shall be collectively responsible to the Lok Sabha. That means at all point of time, they need to have a majority in the Lok Sabha. And at any point of time, the majority is taken back by the legislature for whatever may be the reason, that they are not confident against the entire Council of Ministers, or they are not confident against few of the ministers for their actions. that means the entire council of ministers have to resign. So that is what is collective responsibility. That is why it is also said that in a parliamentary democracy, the ministers swim or they sink together. So that is the idea of the collective responsibility. So in both the countries, they have the system of collective responsibility. So this is also not different. Bicameral legislature, that is existence of two houses in their parliament. In India, we have the House of People, in India we have the House of People, that is the Lok Sabha, and the Council of States, that is the Rajya Sabha. And similarly, so in UK, they have the House of Commons and they also have their House of Lords. So this is also true. So this is also not the right answer. The system of judicial review. If you see the system of judicial review, what exactly is a judicial review? Even if you eliminate, then you still arrive at the answer. There's no doubt. But anyways, we'll try to understand as to why this is the right answer. Before understanding that, what is judicial review? It is a power that is given in the hands of the judiciary to review the actions of what? Under the Indian constitution. Let us take the Indian context. In the Indian context, the judiciary can review what? The judiciary can review the actions of both the legislature and it can also review the actions of the executive. So this is basically what is called as judicial review. So for example, take the example of Article 13. Article 13, what it says? It gives a primacy to the fundamental rights. Any law that is violative of the fundamental rights can be declared to be void by the courts. That any law also includes subordinate legislations which can be done by the executives, or any law that is made by the parliament. If it is in violation of fundamental rights, to the extent of such violation, it can be declared to be void. So that is the idea of Article 13. That means the judiciary is empowered through the process of judicial review to look into the actions of legislature as well as the executive. And if they are found to be violative of the fundamental rights, they can be declared to be void. Not just Article 13, there's Article 32, Article 226, all these articles gives the power of judicial review to the courts. But however, what is the system of judicial review in case of United Kingdom? In United Kingdom, the judiciary is not as powerful as in the case of India, because in India, we have a system of what is called as the written constitution, and we follow the principle of what is called as constitutional supremacy. We follow what? We follow what is called as the constitutional supremacy. So what does mean a constitutional supremacy, or what does it mean by a written constitution? A written constitution is something which is codified into a single document, or even if it is more than a single document, but it is codified. And whatever is there in that particular document is what is the constitution. Outside the constitution, if the parliament or the legislature makes a law, that is only an ordinary law. That means in our country, there's a distinction between what is constitution and what is an ordinary law. And what is having a supreme position or the prime position, that is the constitution, and the constitution is the fundamental law of the country. And what is the power that is given to the judiciary? So we have a written constitution, and whatever that is there in this written constitution is supreme. And who is entrusted with the responsibility of protecting this written constitution? This power is given to the judiciary. So this will be used as a reference point or as a base, and what the judiciary have to decide, that any ordinary law or any of the executive actions, if it is in contravention of this particular written constitution, and they can be struck down as void by the judiciary through the process of judicial review. But however, on the contrary, come to the constitution of United Kingdom. In United Kingdom, they do not have a written constitution. So basically, when I say they do not have a written constitution, it is not that their laws are not codified, but you will have to understand that simply in this way, that there is no single text as what is the constitution of United Kingdom. In fact, every single law that is passed by the British Parliament will automatically become part of their constitution. Every single legislation, every single law that is made by their parliament, every single judgment which is given by their courts, they all become part of their constitution. The conventions that they follow, that become part of the constitution. That means today the parliament can make a law, and tomorrow that law can be amended by another law which is passed by the parliament, and then that becomes the constitution. So in this case, there is no reference point for them to see as to what is the constitution, and that's why we say in British parliamentary system, they follow what is called as the parliamentary sovereignty. Constitutional. They follow what is called as the parliamentary sovereignty. When you talk of parliamentary sovereignty, please understand, in constitutional supremacy, the constitution is supreme. But in parliamentary sovereignty, the parliament can make any law and they can keep changing their constitution. So now come to the context of judicial review in UK. So judicial review here, while in India it can review the actions of both the legislature and the executive, whereas in United Kingdom, the judiciary will have the power to review only the executive actions and not the legislative actions. So this is not possible in UK. In UK, what they can do? They can only just review the executive actions. But can they do review of the legislative action? This is not possible because the parliament can make any law and they can keep changing their constitution and there is no fixed constitution for them as in case of India. So this is the idea that you should have. The kind of judicial review in India is both against the legislative as well as the executive action, but whereas in case of UK, it is largely restricted to their executive actions and not their legislative actions. And that is why we say that they have a system of parliamentary sovereignty, whereas in India, we have a constitutional supremacy. That is why it is also sarcastically said by some of the political scientists. In UK, the parliament of UK is so powerful that they can do anything except changing a man into a woman and a woman into a man. And if at all, if they cannot do something, this is what they cannot do. Otherwise, they can do anything by their lawmaking power. Okay. So what is the right answer? The system of judicial review is different from India and UK. In fact, this topic is so important, it was even asked once in the mains examination, how the Indian judiciary is different from that of the judiciary of United Kingdom, where they converge and where they diverge. This is exactly the question, I think. So, very, very important topic. Okay. Come to the next question. Which one of the following in Indian polity is an essential feature that indicates that it is federal in character? So, please understand. Parliamentary democracy, federalism, cabinet system. So these questions keep coming repeatedly in the examination. So let's go to the question. Statement 1, the independence of judiciary is safeguarded. Statement 2, the union legislature has elected. I'll come back to statement A, come to statement B. The union legislature has elected representatives from the constituent units. That means people get elected from various states into the Lok Sabha. That is what it is mentioned here. The union legislature has elected representatives from various constituent units. Union legislature, which includes both Lok Sabha and Rajya Sabha. Union legislature. Suppose if the question is only mentioning to Rajya Sabha, that there are representatives in the Rajya Sabha from their constituent units, that is the states, you can consider that to be a federal feature. But getting elected from the Rajya Sabha and the Lok Sabha, in Lok Sabha also from the states, it does not represent what is called as a federal character. It only represents that a democratic system where people elect their representatives and send them to Lok Sabha and from where the government is formed. Okay. So this particular statement is not the right explanation. The union cabinet have elected representatives from the regional parties. It does not represent. It is only that the party is spread throughout the country and so they are also from the various parts of the country, or they are in a coalition with various regional parties, and that is one of the reason that the cabinet ministers from there also is in the government. The fundamental rights enforceable by the courts, this does not necessarily explain as to what is a federal provision in the constitution. So the fundamental rights are given and hence it has to be enforced. Okay. So this is not the answer. So even if you eliminate, you can still arrive at the answer. The independence of judiciary is safeguarded. Is it a federal provision? Of course it is. I've already said, whenever there is any dispute between the center and the state, or for that matter any federal units, and then who is supposed to resolve these disputes? These disputes has to be resolved by the Supreme Court under Article 131 of the Constitution. And for the Supreme Court to resolve these disputes, they should be independent. They should not be under the pressure of any of the government, be it center or the state. So the independence of judiciary ensures the federal political system, or to put it in other words, if you say that the federalism exists and to maintain the federalism, you need to preserve the independence of the judiciary. Okay. So the right answer is option A. That is the right answer. Come to the next question. In the federation established by the Government of India Act 1935, the residuary powers were given to whom? Now, if you see the Government of India Act 1935, it is important for a number of reasons. So this is not a very important area, your historical underpinnings as to how the constitution has evolved over a period of time, or what are the historical underpinnings that has influenced the Constituent Assembly in making the Indian Constitution. There is also part of your syllabus. I would say this is not very important, but to be on the safer side, you should not skip. Government of India Act 1919 and 1935 may be very relevant, but questions have come from the other areas as well. But the single most important act before independence is the Government of India Act 1935. In fact, our country was governed even after independence. Till the time we had the independence. We got independence in 1947, and then it took some more years for us to draft our own constitution. The Constitution of India came into force only in 1950. Independence, we got it in 1947. So, between 1947 and 1950, how our country was governed, even after independence, it still continued to be governed under the Government of India Act 1935. So, that is the relevance and importance of this Government of India Act 1935. And also to understand further, for the first time in British India, when the federalism was introduced, for the first time in the British India, the federalism was introduced by the Government of India Act 1935. It is the Government of India Act 1935 that introduced federalism. So, students might have a doubt whether it is by the Government of India Act 1935 or by the Government of India Act 1919. So, don't be confused about this. So, the federalism was introduced in British India by which act? By the Government of India Act 1935. So, there should be no confusion with regard to this. Before Government of India Act 1935, there was Government of India Act 1919. So, in this also there was some kind of federalism, but it is not a federalism. It did not decentralize the power to the provinces. There was only delegation of power, or you can say devolution of power. The power was centralized in the central authority in the hands of the Viceroy or the Governor General of India, but rather he delegated certain powers to the states. That means there is no decentralization as it has happened in the Government of India Act 1935. So, what is the difference between the word decentralization and the word delegation or devolution? That means in decentralization, once a power is guaranteed, it cannot be taken back by any other authority. There is no possibility of encroachment. But whereas in delegation, the power is centralized in only one authority. But because the authority has a lot of work, probably they are delegating the work to an inferior authority. And if they want to take back this authority at any point of time, the delegated authority can at any time take back the authority. And that is what has happened in the Government of India Act 1919. So, decentralization or federalism for the first time brought into the British India by the Government of India Act 1935. And if you see the Government of India Act 1935, the Government of India Act 1935 also in the form of decentralization, they also provided for these lists like the union list, the provincial list and the concurrent list. This was also introduced. So, similar to that of the union list, state list and the concurrent list that we have today. So, this was also introduced by the Government of India Act 1935. So, it provided for the union list, the provincial list and they had a concurrent list. So, the idea is whatever is the item that is mentioned in the union list, the union legislature will make the law. Whatever is the item that is there in the provincial list, the respective provinces and their legislature can make the laws, and concurrent list, both the union legislature and the provinces can make the laws. But however, if a particular subject matter or if a particular item is not mentioned in any of these lists, and suppose there is a need to make a law on such a list, so such items would be considered to be what is called as the residuary list, which is not mentioned, but it is considered to be part of the residuary list. And who will have the power to make laws in the residuary list? It will be in the hands of the Governor General, okay, or the Viceroy. So, it is the Governor General or the Viceroy who will have the power to make laws on the items in the residuary list. So, even in today's constitution, we have something which is called as the residuary powers or the residuary list. And who will have the power to make laws on an item in the residuary list? It is the Parliament which will have the power today, but then it was in the hands of the Governor General or the Viceroy. Again, a very important topic. Please remember this. So, other things you can easily eliminate, okay. So, let us move to the next question with this understanding. I would suggest all the students to prepare thoroughly the Government of India Act 1935. It may be relevant for your mains examination also, once there was a question in the mains examination as well. Come to the next question, which is again there is a comparison between the Indian parliamentary system and the British parliamentary system. We adopted the parliamentary democracy based on the British model, but how does our model differ from that of the British model? Statement 1, as regards legislation, The British Parliament is supreme or sovereign, but in India, the power of the Parliament to legislate is limited. Very much true, because this is the explanation that I was giving the last question, which is related to the British parliamentary system and the Indian parliamentary system, because the British parliamentary system is based on the model of what? Parliamentary sovereignty. They are based on the principle of parliamentary sovereignty. That means they can make any law. Okay, so that is what is parliamentary sovereignty. And in India, the system is based on what? Constitutional supremacy. So the parliament will have the power to make law as long as it does not violate the provisions of the constitution. That's the understanding that you should have. And if any law is violative of any of the provisions of the constitution, then those laws can be struck down. So to that extent, yes, this particular statement is true. Statement 2, in India, the matters related to constitutionality of the amendment of any act of the parliament are referred to the constitution bench of the Supreme Court. So this is also true. Under Article 145 of the Constitution, you have to refer to Article 145. Article 145 of the Constitution is giving the power to the Supreme Court to make rules with regard to how the proceedings shall be carried out in the Supreme Court. In addition to that, Article 145 of the Constitution also says any matter which is referred to the Supreme Court, which involves a substantial question of law or which involves a substantial question of interpretation of the Constitution. So an ordinary law which is to be interpreted based on the provisions of the Constitution is a constitutional matter, and all these things shall be referred to the constitutional bench. And any other matter which is referred by the President under his advisory jurisdiction under Article 143 shall also be referred to a constitutional bench, which shall not consist of less than 5 judges. So this is what the Constitution says. So this particular statement is also true. In India, these matters are referred to the constitutional benches. So select the correct answer using the quotes given below. So the answer would be both 1 and 2, that is option C. But done with the system of government, you can definitely expect one question from this particular area. So what we have covered till this point of time, we have covered the philosophical part, we have covered the system of government. So 4 questions you can say that is in your hand, which you can safely answer, provided that you revise your polity and you also watch these videos. It can definitely benefit you. Now let us move to the next part, that is the executive. So executive, as I already said, what does it cover? It mostly covers the union as well as the state executives. The union executive comprises of the president, the vice president, the prime minister and the council of ministers, including the attorney general of India. And similarly, if you see the state executives covers the governor, who is a constitutional head, and then the chief minister, the council of ministers, and the advocate general. So all these topics, again, very important, and you can expect 2 to 3 questions from this particular area as well, including the various powers of the president and the governors. So let us try to understand how questions are asked, which areas have been more focused when it comes to the preliminary examination, and similarly as to how we have seen in the philosophical part. So we have seen in the philosophical part also which area becomes very important. Every year probably there's a question from the various themes in the fundamental rights, and then they also ask you questions with regard to the concepts like the liberty, justice, the freedom and all those things. And then what is the very idea of right, what is a limited government, what is a constitutional government. So these things become very important, you have to revise them. Similarly, in the system of government, we have understood the questions are coming from the parliamentary system, the questions are coming from the cabinet government, the ideas of federalism, the division of powers, the separation of powers. So similarly here in executives, we will try to understand which areas have been focused upon by the UPSC. You will understand the topics like president, the topics like governor, the topics like Article 77, the power to make the transaction of business rules, the topics like attorney general, the advocate general. So these are all very, very important. The topics like cabinet secretary sometimes. So all these topics has been picked up by UPSC. So we'll try to understand and revise those areas as well. And we'll also try to understand the language of UPSC as we'll proceed further. Okay. So the first question under executive, let us try to understand them. So today we'll try to cover a few questions from the executives part. And tomorrow we'll continue with the executive part and we'll try to complete the executive part in the next class. Okay. Anyways, we'll begin with the executive part. Come to the first question. Consider the following statements. So what the question is saying? Consider the following statements. The Constitution of India classifies the ministers into 4 ranks, was What are the ways that the ministers are classified? Cabinet ministers, ministers of state with independent charge, and ministers of state that is without independent charge, and the deputy minister. So this is what I have explained some time back when I was trying to explain as to what is a cabinet form of government. So under the rules of the government, yes, under the transaction of business rules, the ministership are classified as the cabinet ministers, the highest level of ministers, and then you have the minister of state. The minister of state can be further divided into ministers with independent charge, who is in charge of a particular ministry. Although he is not a cabinet minister, but he is responsible for the administration of that particular ministry or the department. Minister of state without an independent charge, he helps the cabinet minister, he is not having any independent charge. And then deputy ministers anyways do not have any independent charges. They are in line for succession, these people who are minister of state without independent charge and the deputy ministers. All these things are true, but look into the statement. The statement is saying that the Constitution of India classifies. The Constitution of India nowhere talks about all those things. In fact, there is only one article, that is Article 352 of the Constitution, where there is mention of the word cabinet. But no other word is mentioned in the Constitution. The Constitution does not deal with all those things. So this particular statement is wrong. Statement 2. The total number of ministers in the union government, including the Prime Minister, shall not exceed 15% of the total number of members in the Lok Sabha. Is it true? So till the year 2003 and the 91st Constitutional Amendment Act, there was no such restriction. But subsequently, which was not there in the original constitution, but subsequently because of the coalition government means a single party is not having the majority and then there's a coalition partnership. Many governments were formed, and because of this, there's a lot of ministers were added, and too many ministers, it's not good for the governance. And then the government came out to this idea of minimum government and maximum governance. So keep the size and the structure of the government as minimal as possible, but increase the actions and the outcomes of the government. So this is what is minimum government and maximum governance. And in line with the minimum government and maximum governance, the 91st Constitutional Amendment Act was inserted into the Constitution, and thereby they restricted or they reduced and they fixed a limit as to what shall be the maximum number of Council of Ministers. The 91st Constitutional Amendment Act 2003 said that the size shall not exceed 15% of the Lok Sabha. So in case of Lok Sabha, so all these things are there in Article 75 of the Constitution. So the size of the Lok Sabha the size of the ministers at the union level shall not be more than 15%. That means 15% of the size of the Lok Sabha, the strength of the Lok Sabha. Okay. So that is the maximum number of ministers. You can calculate accordingly. Today it is 15 by 100, 15% of 543 members. That is a maximum membership. The same is also true with regard to the states. In case of states also, it shall not be more than 15% of the legislative assembly of these states. But in case of states, please understand, if any state whose 15% strength is, let us assume, less than 12, they can have a minimum of 12. Okay, so minimum is 12 ministers that they can have, and subject to a maximum of 15% of the size of the legislative assembly of the concerned state. But however, in case of union territories which has got a legislature, say in case of Puducherry, in case of New Delhi and National Capital Territory of Delhi, and very soon there will be a legislature there in Jammu and Kashmir also. In these states, in these cases, the size of the ministers shall not be more than 10% of the legislative assemblies of the concerned state. Okay, so this is what is the provision in the Constitution. So with this information, come to this statement. The total number of ministers in the union government, including the Prime Minister, shall not exceed 15% of the total number of members in the Lok Sabha. So this is very much true. So this particular statement is true, while the statement number 1 is wrong. Which of the statements given above is or correct? So the right answer would be option B. Option B is the right answer. Next question. Consider the following statements. Statement 1, it is saying that the Attorney General of the government and the Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of Parliament of India. Not necessarily. Many times, including the secretaries of various governments can also be called upon to know certain information. So not necessarily. The Public Accounts Committee can summon anyone. So in the parliamentary proceedings, anybody can participate, not necessarily the Attorney General or the Solicitor General. So however, who is this Attorney General? The Attorney General is the chief law officer of the government. He is the chief law officer of the government, and his deputy would be the Solicitor General. Although the Constitution does not mention about the Solicitor General, the Constitution talks only about the Attorney General, who shall be appointed by the President under Article 76 of the Constitution. So, Article 76 of the Constitution, the President can appoint the Attorney General, who is usually having the same qualifications as to be appointed as a judge of the Supreme Court. And normally these Attorney General will not have a fixed term, because usually a term of 3 years is given to them, but it is not that they will have a fixed term of 3 years, because under the Constitution, the Attorney General hold office during the pleasure of the President. As long as the President is happy. When we say that the President is happy, that is the ministers are happy, because the President has to act in accordance with the aid and advice of the Council of Ministers. So here the pleasure of the President would mean the pleasure of the Council of Ministers. So whenever the Council of Ministers lose confidence in this particular person, he can be removed by the President and a new Attorney General can be appointed. Although it does not happen practically, but it means very much permissible under the Constitution. And he has to defend the government in the court of law whenever it is required, and he can also attend the parliamentary proceedings and all those things when he is called upon to do so, to defend the government. And he has a right to audience in any part within the territory of India, any court within the territory of India. And he also exercises certain privileges, like when he is taking part in the parliamentary proceedings, he has a right to speech without the right to vote in the House of the Parliament. And when he is taking part in the parliamentary proceedings, he will have all the parliamentary privileges as exercised by a member of Parliament. Okay. So this is what you will have to understand. So this particular statement is not completely true, because it is not restricted only to the Attorney General and the Solicitor General. Okay. So this is wrong. Come to statement number 2. According to the Constitution of India, the Attorney General of India submits his resignation when the government which has appointed him resigns. Now, please understand, this is just a conventional practice. It is not mentioned in the Constitution. So here the information that they have given might be true, but this is not something which is mentioned in the Constitution. So because here it is mentioned according to the Constitution. Although it is not mentioned in the Constitution, why do you think that the Attorney General will submit the resignation whenever the government changes, when the government resigns? Because Attorney General is appointed by the previous government and he is in close confidence with the previous government, and the responsibility of the Attorney General is to defend that particular government in a court of law whenever the government asks him to do so. So that means there should be a relationship of trust between the government and the Attorney General, which may not be the case when the new government comes. So when the new government comes, probably the new Council of Ministers might advise the President to remove the Attorney General. So what the Attorney General does, he automatically submits his resignation. So this is a conventional practice, although not mentioned in the Constitution. So the statement is true, but not in the Constitution. So this would also be wrong. Which of the statements given above are correct? The statements that is given above, which are correct. So both the statements are not correct. So probably the right statement is option D, that is neither 1 nor 2. Now come to statement number 1. It is saying that the Attorney General of India and the Solicitor General of India are the only officers. Now please be very cautious of this word only. Whenever this word only is used, or any extreme statement or extreme word is used in UPSC language, mostly that statement is going to be a wrong statement. 99% you can say that it is going to be a wrong statement. So this is how you have to understand the language of UPSC as well, but sometimes it might be true also. So that is why I am saying it is in 99% of the cases. Any extreme statement mostly is wrong, only is always wrong, but sometimes it may be true. So you should be aware and you should be carefully choosing your options when you attempt in the examination. Okay, come to the next question. Which one of the following suggested that the governor should be an eminent person from outside the state and should be a detached figure without intense political links and should have taken part in the politics in the recent past? So please understand, now there is a question from governor. Earlier you have seen a question from the Attorney General. Before that there was a question from the Council of Ministers. So these are all very, very important topics for the preliminary examination. So which one of the following suggests that the governor should be an eminent person outside the state and should be detached figure without intense political links or should not have taken part in the politics in the recent past? So the answer to this particular question is very simple. It is the Sarkaria Commission. In fact, Sarkaria Commission was the first commission which was to be appointed to study the center-state relationship in our country. So, in any federal political system, there is always a conflict between the center and the state. So, the center has appointed a committee to study as to how to remove the conflict between the center and the state. In fact, the Sarkaria Commission has given a number of recommendations with regard to how to smoothen the relationship between the center and the state. But one area he stressed upon is the role of the governor, because the governor's office and the governor's powers and functions is very, very important to ensure the smooth functioning between the center and the state. Keeping this in mind, the Sarkaria Commission said that anybody who is appointed as a governor, it has given certain recommendations to ensure the independence to the office of the governor, and so that the governor acts in a much more neutral manner, and he is not just acting as someone who is an agent of the center. In fact, the word agent is not very appropriate, so that's why the Supreme Court said the governor is just a link between the center and the state, or he is a representative of the center to some extent, but he is not an agent. But unfortunately, there are a lot of governors in our country who has been creating a lot of problem to the state, acting in a biased manner, trying to bring in the agenda of the central government and trying to implement the ideology of the central government, although that the people in that particular state have elected their own government, and that government has its own ideology. And taking all these things into consideration, the Sarkaria Commission said that few things has to be followed by the president before appointing the governor to a particular state, so that you can ensure a better relation between the center and the state, which has not been followed even today, unfortunately. So, what are the recommendations that is given by the Sarkaria Commission? In 1983, the Sarkaria Commission said that the governor should normally be an outside person, a person who is outside that particular state. So, this is to some extent followed as a convention today, even today. He also suggested a person should have actively retired from politics. Actively retired from politics, but today it may not be, you cannot say that it is completely followed. People just before being appointed as a governor, they are very much active in politics. So, this is something that he has suggested. And he has also suggested to give a security of tenure to the governor. How to give a security of tenure? So, the governor should not be removed in the first place, and if he is removed, the reasons should be given in writing to the governor, which is not the case today in our country. So, this was also suggested by the Sarkaria Commission. In addition to all these things, the Sarkaria Commission also said, whenever somebody is chosen as a governor to be appointed to a particular state, the chief minister should be consulted by the president. The CM is to be consulted and he is to be taken into confidence. But none of these things, unfortunately, is not followed. And the office of the governor has also been used to create problems and pressure to various state governments. So, this is not to say that one party is doing this. Any party which is there in power in the center has been trying this, has been doing this to the opposition parties. So, which is really unfortunate and not very healthy for our federal political system. So, the right answer is option C, that is the Sarkaria Commission. And apart from that, there are also other things. Say, for example, the first Administrative Reforms Commission. This is not specifically related to the reforms in the governor or something. This is to bring in overall development in the entire administrative system of India. Okay. So far there has been two Administrative Reforms Commission, one in 1996 and other is in the early 2000. Second is the Rajamanar Committee. So, this Rajamanar Committee is also to look into the center-state relationship, but it is not a committee which is appointed by the central government, but by the state government of Tamil Nadu. Okay. So, this is what is Rajamanar Committee. National Commission to review the working of the Constitution. This is to review the entire Constitution, which was headed by M.N. Venkatachalaya, a retired Chief Justice of India. And this is also not related specifically to this particular question. So, the right answer would be what? The right answer would be the Sarkaria Commission. There is also one more commission which is appointed by the central government, which is the M.N. Punchi Commission. And this M.N. Punchi Commission has also given recommendations with regard to the center-state relationship. Unfortunately, that recommendation is also not followed, and a similar recommendation with regard to governor is also given by the Punchi Commission. Come to the next question. If the President of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state, then, so we'll have to understand as to what is the power of the President under Article 356. Under Article 356, the power of the President to impose a President rule or a state emergency. You can say that is a President rule, or you can say that is the state emergency. It is also called as the state emergency. So, under Article 356 of the Constitution, whenever there is a constitutional breakdown, this is very important. Whenever there is a constitutional breakdown, the president can impose the president rule. So what is this constitutional breakdown? What is constitutional breakdown is not defined in the constitution. The constitution only says under Article 356, if any of the state government is not able to carry out the administration in accordance with the provisions of the constitution, then the president can impose a president rule. So this is basically what is considered to be a constitutional breakdown. And the president can impose a president rule either by himself or on the report which is sent by the governor. When I say that the president can do it by himself or on the report of the governor, in both the cases the president is supposed to do based on the aid and advice of the Union Council of Ministers. So here the report of governor is not mandatory. That is the important understanding that you should have. So what can be considered to be constitutional breakdown? Suppose if the state government has lost the majority, the state government is having the majority but they are not able to prevent the law and order in that particular state. There is a lot of law and order issues and the public peace and tranquility is affected. The state government is engaging in anti-secular activities. So all those things has been the instances on which Article 356 has been invoked in the past. But there are a number of other things with regard to Article 356 as to how it can be invoked, what is the procedure, what is the need for parliamentary approval, and how long it can be extended. To get an idea of all those things, you can watch on to the previous videos on the 100 most important topics for polity in 2023, which is already there in the StudyIQ English channel, where it has been elaborately explained. But the most important thing is coming to this particular question. So whenever the president rule is imposed in a particular state, the federal political system turns to be unitary in character. So from federal, which is normally a federal political system, it goes in the direction of what is called as unitary in character. So this is the likely consequence when the president rule is imposed. So let us try to understand which this particular question is focusing upon. What is the consequence whenever the president rule is imposed in a particular state? So as I already said, it will move towards federal to unitary in character, but only with regard to that particular state. The other states and their relationship gets unaffected, remains unaffected when the president rule is imposed in a particular state. So what are these consequences? The two most important consequences. The first consequence that is likely to happen is whenever the president rule is imposed, then the president is going to take up the administration. And when the president is going to take up the administration, what is the need for the Council of Ministers in the state? There is no need for the Council of Ministers, because till that point of time they were carrying out the administration. Now the president himself is going to take it up, and hence the first thing that will happen is you dismiss the Council of Ministers. So dismissal of the Council of Ministers, that's the first thing. Okay, so that is a very likely consequence. Second consequence, whenever the president rule is imposed in a particular state, now the parliament will take up the power to make laws instead of the state legislature. So if the parliament is going to take up the powers of making the laws for that particular state, what is the relevance of the concerned state legislature? So the state legislature can be dissolved. State legislature can be dissolved. But however, please understand, unlike the dismissal of Council of Ministers which happened immediately, the state legislative assembly will not be dissolved immediately. The assembly will be dissolved, but only after the parliament gives the approval for the imposition of the president rule, which under the constitution, whenever the president rule is imposed, the parliament has to give the approval within a period of 2 months. So within 2 months, the parliament has to give the approval for if the president rule is to continue in that particular state. And once the parliament gives the approval, then what happens? The state legislative assembly, the legislative assembly is dissolved. The legislative assembly gets dissolved. They will be dissolved. But before the legislative assembly is, before the parliament gives the approval, the legislative assembly cannot be dissolved. It will remain intact, but it will not perform any functions. It will be there, but it will not perform any of the functions of the legislative assembly, and that is what is called by a state which is called as suspended animation. So till that point of time, it will be kept under a situation of what? It will be kept under a state of suspended animation or animated suspension. Okay, so with this information, let us get into the question. So let us try to answer this particular question. So what is going to happen when the president rule is imposed in a particular state? The assembly of the state is automatically dissolved. So the assembly of the state will not be automatically dissolved. So this is very important. The Council of Ministers will be automatically dissolved, but not the assembly. The assembly will be intact and it will be kept under suspended animation. unless and until the parliament gives the approval, which they have to do it within a period of 2 months. So this particular statement is wrong. Come to statement number 2. Statement B. The powers of the legislature of the state shall be exercisable or by an authority of the parliament. So I'll just come back to this particular statement. Come to statement number 3. Article 19 is suspended in the state. Now please understand, the president rule has no relation to suspension of fundamental rights. The suspension of fundamental rights can happen only in case of the national emergency, which can happen under Article 359 of the Constitution and to some extent under Article 358 of the Constitution. So no relevance to the fundamental rights. That's not the consequence. Okay, so you can eliminate this particular statement. The president can make laws relating to the state. The president cannot make laws. The power is given only to the parliament. When the legislative assembly is dissolved, the parliament will take up the power, but the parliament may delegate this power to somebody else also, including the president. So it does not directly go to the president unless and until the parliament delegate this. So the most appropriate answer for this particular question is that the power of the legislature of that state shall be exercisable by or under the authority of the parliament. So it is exercisable by the parliament, or the parliament may delegate this authority to somebody else. So the right answer is option B. So please understand, we have just started seeing few questions. You can understand the questions are coming from the areas of Council of Ministers. The questions are coming from the areas of the powers of the president, that is the state emergency. It is basically the powers of the president. And we have also seen a question from Attorney General. So in this way, we'll try to understand the important topics, and we'll also keep revising these important topics for the preliminary examination. Okay. So with this particular question, we'll end our class here today, and we'll continue our discussion with the executives again in the next class. So we'll try to complete the executives in the next class, and if time permits, we'll move on to the legislature also, which is again a very important topic. So probably before coming to the next class, you can revise the executives part, and then probably you can watch these videos, which will be much more beneficial. And then day after tomorrow, we'll take up the legislature part as well. So in this way, we'll try to cover every single topic which is asked in the last 15 years of question paper from the subject polity. Okay, so keep watching all these videos, and I'm very sure that it will be beneficial for you in the long run, and also before you go for the preliminary examination. All the very best. Thank you very much. God bless.